Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court, other court issues, as well as CPS. I am your host, Marianne Petrie. I am happy to have return guest on, Stephen Boyd. He's founder of the Gabriella Boyd Memorial Foundation. And I had him last on February 9th, 2024, season 5, episode 72, where we discussed what went wrong in his whole case. And right now we're going to talk about a protest family court rally and that will be happening next Friday. And we're also going to talk about how his civil suit got dismissed by Judge Jim Hubert in the Westchester Supreme Court. Another bad decision by a judge. I welcome you, Stephen Boyd. How are you?
I'm well, Marianne, and thanks for having me again. And congratulations on all the episodes of the podcast. I think you're doing a great thing, and I wish many, many more to come.
Oh, thank you. So now
Um,
this rally is going to be Poughkeepsie?
yeah, this family, it's a family court reform rally, and it's actually being held by the National Parents Organization, the New York chapter. My friend and ally, New York chair, Mr. Andre Rainey, put it together. And it is next Friday, as you mentioned, May 24th from 10:15 to 12 noon. And it's actually going to be on 31 College View Avenue. That's one word, College View Avenue in Poughkeepsie, New York. And it's going to be held in front of the Brooke Brady and Shopper Divorce and Family Law Building. And
Oh,
I just
good.
wanted, to put it out there to everyone, everyone who's local. If you guys can come out and show a little bit support, our foundation will be there amongst many, many others. Media will be present, and it's going to be a good time.
I think everyone should go and support, even though anyone who's listening, yeah, if you're close to this area, please go, even if you've never been to family court, but just stand with these parents because you never know if one day it could happen to you or your grandchildren.
Absolutely. I mean, you may not, I always tell people it may not be happening to you, and I hope it never does.
Mhm.
However, I can guarantee you probably know someone who is going through it, and you're just probably more than likely unaware.
Exactly, exactly. And that is in front of Brooke Brady.
And Shopper, Schopfer.
That's a last name.
Yes, yes, it is.
Schopfer. Okay, law firm. All righty. All righty. Okay. So, tell me about your civil suit and, why did it get dismissed by this Jim Hubert? Um, Another poor decision made.
Um, yeah, it's mind-boggling. It's mind-boggling. It's disheartening. Um, because you hear these things about, you know, our justice system, and people always talk about, well, there's always conflicts of interests, and maybe there's some relationships going on, and who's covering up for who. There's a big cover up. Who's buddy buddy with who and knows somebody. Um, who's in bed with somebody, who goes golfing with them on the weekends, and so on and so forth. And I'm not saying that's what's going on here, but it does raise the question, when you have, like my case, a really black and white issue here.
Right.
I had a legitimate court order in hand. I went to the police. I was advised by my attorney the whole step of the way, every step in the process. And there was, like, check mark after check mark after check mark going down my list in the boxes, that I made sure all my bases were covered, my T's were crossed, my I's were dotted. And I have people come up to me till this day, and they're saying, Steve, it was such a black and white issue. Like, you did everything right, and clearly, something tragic happened. You lost your daughter. How didn't this case get resolved yet?
Mhm.
I remember this all happened in 2018. We filed the civil suit in the end of 2019, not in the end, but in 2019. So, we've been waiting all this time. And, people come up to me and say, well, there has to be something going on. And like I said, is it possible? Absolutely. I don't put it past anybody, and I don't even want to go down that rabbit hole because it's very easy to draw connections and conclusions and connect the dots. You have these law firms that obviously donate to political contributions for campaigns, and you have maybe personal relationships in a professional setting, and there are so many different variables that can be a conflict of interest. And you know what? I am 100% sure there are a few in my case, and
Mhm.
like
That's a shame.
on why this happened. But I mentioned them in our last podcast that we did, Marianne. My friend, my family member, my attorney, Martin Rosen. He said justice delayed is justice denied, and there has to be some kind of reasoning on why we haven't gotten justice yet.
Oh,
Um, I just want to kind of touch on a couple things with the Second Department, the Appellate Division. It is in New York. It is one of the most backed up departments there is. I mean, everybody has an appeal, and it consists of a lot of different counties in New York State. I believe Queens, the Bronx, Westchester. I believe Rockland's in there, and there are so many counties there. And I totally understand that it's backed up and it's going through the system and it's going through the process.
mhm.
Um, and I get that. We have to wait our turn. There are people out there who have appeals. Maybe they were wrongfully convicted of a 10-year sentence or a 20-year sentence, and they also have the right to appeal. And I get that. But just as a matter of law, what I would like to discuss is why our civil suit shouldn't have been dismissed in the first place. Judge wrote a 34-page decision and order to dismiss our civil lawsuit in the entirety. And a lot of the substance in that decision and order, in fact, is not correct as a matter of law. And there are mistakes and contradictions and reasonings that, quite frankly, are just completely false. So I'd like to, just for the record and to the public, kind of speak on a few of those things, because like I said, a lot of people don't like to ask me about it because it's a sad thing. It's not something we all like to talk about, and everyone just kind of keeps their mouth shut and, hey, how are you doing, kind of thing. But I'd like to take this time just to really explain to people the reasonings and the rationales behind number one, why the judge on his part dismissed the suit, and number two, why that was incorrect to dismiss our lawsuit. So those are some of the topics that I like to cover in this podcast we're doing
Right.
today. One thing I would like to just point out is that as I mentioned, the Second Department is backed up and so on and so forth. What I have here, just for a comparison, okay, we're gonna call her, for lack of a better word and keep this PG, we're gonna call her the witch.
Oh,
Okay.
you're allowed to swear.
Well, we'll keep it PG for everybody.
Okay.
We'll refer to her as the witch. And when I mention that, that is obviously the individual that obviously took my daughter's life on April 28th of 2018. And the reason why I just want to bring that up is because um, she was sentenced on a criminal hearing by obviously the district attorney's office and the prosecutors there on October 31st of 2019.
Mm.
Okay. That's when she was sentenced. Ironically, it was Halloween. Um, exactly. Go
Yeah.
figure that. Um, She was sentenced then. She was sentenced to 25 to life on a concurrent sentence for two different charges. One obviously being murder in the second degree of my 2.5-year-old little girl, which I had to fight with the district attorney's office to get that charge as as a number one charge.
Mhm.
They wanted to charge her number one with aggravated assault on the police officers. To me, I'm a street guy. I've been around the block more than just a couple times. If you're going into prison, you're going in there as a baby killer, that's not a good look.
Mhm.
That's bottom of the barrel. That's like the rapists, the pedophiles.
Mhm.
I wanted her to go in there as that. I did not want her going in as a cop killer or an attempted cop killer or anything like that. So I had to fight, and they understood where I was coming from and agreed to charge her, even though it was a lesser sentence, mind you. Um, it was a lesser sentence, but it was more important for me for street justice for her to go in there for that charge than for being 2 counts of aggravated assault on
Yeah.
the police officers. You know what I mean? So that's what she was charged with, those two
Oh.
crimes. She ended up pleading guilty. Now, the reason why I'm speaking on all this is because, wouldn't you know, 2 years later in April of 2021, uh, an appeal was filed with the Second Department, and she was trying to get out of her sentence early
Oh.
on a 25 to year life sentence for those two charges. They filed an appeal, and I have the paperwork right here. It's
Wow.
here. And the reason why I want to just bring that up is for this. So that was filed by some law firm, small time law firm
Mhm.
on her behalf. And just a tidbit to that also, you see how these law firms operate. Um, the criminal trial was very thorough. Okay. That
Mhm.
was a very, very in-depth, very meticulous, methodical trial and prosecution. Okay. They made sure that she understood exactly what was going on, exactly what she was saying on the record. They took every precaution that was necessary. And many thanks to Judge Barry Warhead, who actually made the sentencing on that day, for doing that.
Mhm.
So, as a follow-up, that an appeal obviously would be shut down because of the thoroughness
Mhm.
that professionalism that he was able to keep in his courtroom. Um, so my point with that was that money was just being taken from her mother at the time, just so this law firm could try and file an appeal um, with not even the slightest chance of any kind of shot of getting out early or getting released or a lighter sentence or anything. But they were willing to take the money and try, right? And
Mhm.
point about some of these law firms and so on and so forth. No matter what it is, most of these attorneys and these firms, they just want your money. They
Mhm.
know you have a shot in hell, but they'll take your money and say, well, we'll give it a shot and we'll try. And to me, that's not right. You should be upfront with your client, and you should be honest, and you should let them know and say, hey, look, listen, I don't even want to attempt this. I don't even want to take your money because you have a 0% chance of trying to get out of here.
Mhm.
Uh, so I just wanted to touch on that. Um, Mind you, the Second Department got back with their verdict, and it says it right here. That it was filed on April of 2021. They got back on July 28th of 2021. So what is that? 3 months, I believe, right?
Mhm.
I mean, you're talking about 3 months they got back, and quote, it said that the judgment is affirmed. So
Good.
no shot in heck to get that sentence, lifted or, early release or anything like that.
Good.
So that just gives you an idea, even though it was in the Second Department, okay, that in a
Yeah.
matter of months, it was already made, a decision was made.
Mm-hmm.
Now, mind you, I've been in the Second Department since my civil suit got dismissed by this judge, James Hubert. Our suit got dismissed in February of 2021. Okay. And we immediately filed a motion to appeal on that.
Mm-hmm.
We've been waiting since February of 2021, and we're now in May of 2024, and we've been waiting in the Second Department for a hearing.
Oh,
And like I said, I totally understand they're backed up, but for you to make a decision and a ruling on something in a matter of 3 months, to me, to be waiting for, what is that, 5 years, I believe,
oh my
some
God.
it just goes back to the point that I said a little bit earlier, that justice delayed is justice denied.
Mm-hmm.
This isn't a small case. This isn't, somebody took somebody else's lunch money here. This is a big deal. A little girl lost her life.
Mm-hmm.
And not to diminish anything about anybody else's case, but like I said, is it possible for cases to be, solved in a matter of months? Absolutely. I have proof of that right here. So we have been waiting in the Second Department, and we will continue to do so. I'm in contact with my lawyers, not too frequently, but I have reached out to them earlier in the week, just to see if there were any updates on it. And that's where we're sitting right now. Just a little tidbit about that as well. With my case, it was very, very complex. It was complex and it was delicate because you had two different scenarios here. And I believe I talked about this a little bit on our first podcast,
Mm-hmm.
how there was a civil matter that became criminal, and it became criminal real quick. So
Mm-hmm.
you have to remember that, you can go from a civil matter and it could change in a matter of seconds into something criminal. And once again, the police have to be aware that, assistant district attorneys have to be aware of that. And a lot of them may be aware of it, but they don't know the laws and how to go about proceeding when that occurs. And that's something I'm going to discuss in a little bit as well. But yes, so with my case, we had to wait for the criminal trial to conclude.
Mm-hmm.
We couldn't file our civil suit because in our civil suit, the office of the DA and the assistant district attorneys were defendants in our civil suit. Well, these people are the same people that are prosecuting her for the charge of murder in the second, and murder, an attempt, and aggravated assault on a police officer, 2 counts.
Mm-hmm.
You know what I'm saying? So we couldn't file a civil suit until that criminal trial concluded. Because right there, anyone could see that it would have been a conflict of interest right there.
Mm-hmm.
You're expecting justice from people that you're eventually going to sue. It just doesn't, it
Right.
doesn't add up. Thank God that, as I said, the judge in that criminal trial, Judge Barry Warhead, a great man, made the decision that he made upon the evidence, and the prosecution at the DA's office did an excellent job prosecuting her on the criminal case, and it all worked out. After that concluded on October 31st of 2019, we were able to move forward and go forward with our civil suit.
Mm-hmm.
So that's why, my case, there's a lot of variables. It's a lot of complexity there because, as I said, it crosses over, to different areas.
Mm-hmm. Right. That case has a lot going on. And as you said, you've been sitting on it since 2021 to 2024.
Right. And like I said, did we expect a dismissal in the state courts? Absolutely not. And I'm going to get into this in a little bit. I got a great team of lawyers. These guys are top notch. The experience between the three of them is over 100 years.
Mm-hmm.
These guys are my family
Mm-hmm.
to me, because they are trying to obtain justice for my family.
Right.
So I consider them part of my family.
Mhm.
Um, the team that wrote our summons and complaint that got dismissed by this judge put in time, they
Mhm.
put in effort, they put in the time to back the claims up with case law,
Mhm.
and 156 pages. And I just want to make sure that's correct. Our summons and complaint was 156 pages. It is bulletproof. You could shoot that thing with a 9 millimeter round and it wouldn't even, break through. That's how good this summons and complaint was. When I tell you our causes of action and our lawsuit for obviously negligence and wrongful death,
Mhm.
and the case law that we have and our evidence and testimony and everything else, that thing could hold up in any courtroom by itself, affidavits and all. Um, it was great. It was a
Mhm.
masterpiece.
Oh.
Is what we ended up calling it, was a masterpiece. Okay, and in a matter of months of that being filed, this judge, whom I believe that he didn't even read it.
Oh, I bet.
I believe he
No
gave it
doubt.
to some kind, right? You know what I mean? I'm pretty sure he gave it to the law secretary. It was too long. The law secretary just had to summarize it for him, the paralegal, whoever, and that was that. You know what I mean? Um, I believe that that's what happened, because anybody with half a brain that would have read this would have been like, man, everything is spelled out right here. This
Mhm.
is this is ludicrous how this could have happened. There has to be some kind of accountability here and some kind of recourse for the actions that weren't taken or
Mhm.
the actions that were taken. Um, and instead of that, smack in the face, spit in the eyeball, we got dismissed out of state court. And I just want to read a little bit um, about this judge's right here, the decision in order that we have here, 34 pages by
Ugh.
Justice Hubert. Um, and I'm quoting here on, this is just an excerpt of why the Smith the why he made the decision that the suit should be dismissed. Um, and it says, dismissed entirely due to the absence as a matter of law of the existence of a special duty, and is further ordered uh, so much of the motions that seek dismissal of the plaintiff's causes of action pursuant to CPLR statute 3211A 1 for failure to file the notice of claim, and such causes of action seeking and pleading punitive damages are moot. Um, Essentially, he dismissed it for a couple different reasons.
Mhm.
Um, Speculativeness was one of them. Ministerial versus discretionary acts. The need of a warrant, which was completely incorrect. And obviously the two things that I just mentioned, the existence of a special duty by the police that was owed to me, as well as the CPLR 3211. That's just technicality stuff. That right there is like, I don't care about the whole substance you got in your summons and complaint, but I care more about how it was filed, when it was filed, the time that it took for you to file it, and so on and so forth. So that to me is just a cop out. We actually filed everything on time and in the manner that it was supposed to be filed. And I'll also correct that on why that shouldn't have even played a part in his
Oh.
decision, as well as a couple of the other, the couple of the other reasons why he made his decision to dismiss it, should not have been. Um, so like I said, with that being said right there, anyone else who, would read this 34-page order in its entirety, you know, would be like, okay, maybe there's something there. Maybe this judge is correct. Seems like he knows what he's talking about. But the people that know what they're talking about, and believe me, I was there, I was one of them, and then again, being coached and schooled and picking up and learning from what the lawyers are all talking
Yeah.
about, because I'm in the room and we're discussing how this is even possible. you learn real quick, like, hey, well, listen, this is a mistake. This is egregious. This is erroneous. I mean, as a matter of law, as this judge stated, his opinion or his reasoning, his decision is incorrect as a matter of law.
Hmm.
And right now, I'm just going to take a little bit of the time to actually dive into that on why on why my civil suit should not have been dismissed by this judge. And I'd just like to make a couple of corrections on the errors that were committed in this decision-making process.
Hmm.
Um, so as I stated, there was a couple of things there that the average person would say, okay, the existence of a special duty, what is that? The need for a warrant, okay. Um, and like I said, the technical stuff as the 3211, I just want to go back to it a little bit here and see what else he's saying. Oh, the Fourth Amendment, which is the right to privacy. Okay, he said that's the reasoning why it should be dismissed because she was protected by the witch. If we all remember that term that I used earlier
Hmm.
here, the witch was protected by the Fourth Amendment, and that's incorrect as well.
Right, right.
You know what I mean? As a matter of law, that's incorrect, and we have the case law to back that up. So
Uh,
I'm actually going to correct it for the record and just continue on why, we actually shouldn't have been um, dismissed in the first place.
exactly. I'm so sorry.
It's like I said, it looks bad. It just looks bad for the courts. It looks bad for these judges. It makes everyone think that all these attorneys are colluding together. The judges, the attorneys are colluding together. The judge is protecting the district attorney. The district attorney is trying to protect his ADAs. CPS, who was listed as a defendant, is wrapped up in it. So who is politically connected to CPS? And, like I said, you can't blame somebody for thinking, well, hey, it's called covering your ASS. It's called, protecting the people in power. And it's wrong. It's
Right.
wrong. Listen, I'm a truck driver. I drive a truck. If I was to crash into something or run into a car or take down a power line or something, I have to own up to that. That was my fault. I made the mistake. I have to sit around, wait for the police report, and so on and so forth. I have to tell my boss, because I made the mistake. That doesn't excuse these people from nothing either. If you make a mistake, you have to own up to the mistake. It's
Mhm.
that simple. But so our first critical, and I'm going to call it a slam dunk issue. This is the terminology we came up with sitting down at the table discussing, the decision and the order. Me and the attorneys together. The first slam dunk issue is this warrant issue. Okay, and I actually have the actual TOP or the PRO that was supposed to be served and was served
Mhm.
um, at her house that granted me from Judge Hal B. Greenwald, who is an amazing judge. He's a family court judge, Justice Greenwald. Him and my attorney, Martin Rosen, were the only two people that done something correct, that done the right
Right.
thing in the whole process. This judge was able to issue us the court order, the TRO, the temporary restraining order, or the TOP, temporary order protection. They're interchangeable. He read our affidavit. He read our order to show cause on why we were seeking a substantial change in circumstances for custody. He could have struck down anything that we wrote and marked it for a later hearing, a later date for a hearing.
Mhm.
Okay. The allegations that we alleged, she's doing drugs, she's suicidal, she went AWOL, she abandoned the child for a period of more than 12 hours or something. All these allegations we alleged in our order to show cause in the GF40 form that I had to submit to the courts for a substantial change in circumstances to our parenting agreement that was, you know, in 2016. So 2 years from then, 2018, this judge could have struck down. But the judge did the right thing. Judge Greenwald erred on the side of caution. He says, you know what? This is very serious. These are very serious allegations. You know, it was a weekend coming up. It was, you know, it was a, you know, and he wanted to get that baby out of the house immediately and place her in my custody so I could have physical custody with a stay away directive, okay, and a no contact clause. That's powerful language, and I'm going to get into that as well. It's very powerful language that it says it's further ordered that not only is the Gabriella, the minor child, supposed to be placed in Mr. Boyd's physical custody, okay, but it is also directed to stay away from the petitioner and the minor child. So there was a no contact clause that was put in there too to show the seriousness and the severity of the situation. And the judge and my attorney, thank God, did the absolute right thing, erring on the side of caution to grant me this order of protection and grant my daughter the order of protection. Okay? I have that order. I just had to go off on a tangent there and explain that because
yeah.
that was something just popped up on my screen. We're good though. It was important. It was very important. Let me just get my paperwork in order here. Okay. So the first critical slam dunk issue, as I was talking about, was the warrant issue, right? One of the reasons why this judge dismissed our suit was because he said that a warrant was needed. Well, that's correct. It wasn't needed. And that's probably a fairly common mistake, but unfortunately, it probably cost many lives as well. The warrant issue, we never claimed that the TOP, the document that I just showed you guys, we never claimed that that TOP was a warrant, okay? A warrant, like a temporary order of protection, is a court order. The former, by definition, in criminal procedural law 120.80, okay, both must be enforced by the police, as per case law, case Valdez in Court of Appeals. The court erroneously claims that our TOP did not direct the child's removal from the house. It didn't direct the child's removal from the house. Well, what does the stay away and change of custody wording provisions mean when everybody knows that Gabriella is with the witch, okay, inside the house? I mean, that's just semantics and word games, okay, by the court, especially since the village police, they knew from a police incident report that that they were assisting with a custody exchange. So when I went there, you know, an incident report was made, and on that incident report that we have, it says a custody exchange, assistance with custody exchange. So they knew all this, you know. And as I said, the judge claims that the order that I had, that I just showed you guys, did not direct the child's removal from the house. That doesn't matter. How am I supposed to get physical custody of my daughter if she's not removed from the house?
Right.
There's a way directive in the order. How is she supposed to stay away from me and my daughter if my daughter's still in the house? Clearly, she has to be removed from the house. So this is just word games that the court is playing here, and semantics that, you know, are trying to belittle the order that this Justice Hal B. Greenwald afforded us. It's semantics. There are only two ways an arrest could be made in New York. Okay, I'm just talking about New York here. Other states are different. You can have citizens arrest and so on and so forth. In New York, you can be arrested with, or you could be arrested without a warrant. Okay, this is basic stuff. No one disputes that when that witch slammed the door after the cops read and handed her the the TOP, or the temporary order of protection, okay, no one disputed that it violated the stay away directive that was in the order. Okay, how is she supposed to stay away from us both if Gabriella is still in her custody?
Mhm.
Okay, no one disputed that, but the judge ignored that simple fact because he dismissed the suit, as I said previously, because of, well, the order didn't direct the police to physically remove the child. Semantics, it's word games.
Uh-huh.
Um, so once violated, okay, the witch's arrest was mandated. She violated a court order. She did not comply with the order. An arrest was mandated. Okay, that's called contempt. It's called obstruction.
Mhm.
It's many things that she could have been charged with. Okay, but criminal contempt would be the number one thing that I would go to effect an immediate arrest
Oh.
because she was read an order, she was handed the order. It's an order from the courts and it's enforceable.
Mhm.
And those officers, either ignorant or didn't know, whatever you want to call it, weren't trained properly, did not affect the arrest. Okay. So her arrest was mandated. It wasn't merely authorized. Okay. Um, that removed the discretion out of the equation. She had to be arrested. She committed a crime in front of the police officers.
Mhm.
Okay. The question was, should she be arrested with or without a warrant? Because there's only two ways that you could do that. Okay. Now, the answer is, as I told you in our previous segment that we did, I don't know if anyone's continued listening and remembers when I said this, but Criminal Procedural Law 140.10 and 140.15. Those are going to be your best friends, guys. Please, everyone listening out there, remember CPL. Go through your CPL, CPL 120.80, CPL 140.10, CPL 140.15. These guys are the right to arrest without a warrant. Very important stuff.
Oh, yes.
Okay. I talked about that in pretty good depth on the podcast that we did before. Um, so should she be arrested with or without a warrant? Well, guess what? There wasn't time to get a warrant. So Criminal Procedural Law 140.10 mandated that arrest without a warrant. It was enacted in 1994, okay? And 140.15 authorized that arrest forcibly inside premises without a warrant. Okay. So the whole, oh, well, I don't know if we could go through the doorway because it's it's that she's protected by the Fourth Amendment and all this nonsense that, these people are talking about. Well, guess what? CPL 140.15, because a crime was committed in the
Mhm.
presence of a police officer, they are mandated to arrest and could forcibly go inside the premises
Mhm.
without a warrant. Okay.
Mhm.
And that was that case law. We have case law to back this up. I'm just not, shooting from the hip here, guys. All right.
Mhm.
That case law is United States Supreme Court. Okay. Peyton versus New York. Okay. That was the case in 1980. All right. Um, says that they can't enter into the premises to make an arrest without a warrant unless there is exigent circumstances. Well, in my case, there definitely was exigent
Oh,
circumstances, okay?
yes.
Child was in
Uh,
danger. We said that. The police, everyone knew that she was in danger. Gabriella was in danger. We need to get her out of the house. There was exigent circumstances that existed here. The judge says that there was none, okay? The judge is wrong.
mhm.
Okay, because the legislator enacted in 140.10, subdivision 4, says that a stay away violation mandated an arrest without a warrant because it recognized inherent exigent circumstances when there is a violation of a stay away provision in an order of protection and there is no time to get a warrant. So that just smashes the judge's rationale to crap.
Mhm.
Um, and like I said, that's 140.10, 140.15. But in that whole statute, you have subdivision 4, which is what we're talking about as far as exigent circumstances goes, that because our TRO or TOP that we had a powerful language. Remember, it's powerful language, a stay away directive. Okay, these police were were well within their rights to go into that house and extract Gabriella and place her in my custody as the order dictated them to do. So that should be enough for the warrant requirement right there. I'm going to move on a little bit because I could keep on talking about this, but we got a lot to get to here. There's a lot to get to. Let me see what else we got. So he said some stuff about speculative things. And there was a few other things, but we're going to keep let's see what else we got. Yeah, I could keep on going on the warrant. I'm gonna cut it loose right there though. Let's go to the special duty. Well, let's talk about this because I said that it was dismissed because there was no special duty that was owed to Mr. Boyd. Mr. Boyd, didn't justifiably rely on the police and this nonsense of things that the judge said happened that didn't really happen the way that he said it would. So the second slam dunk issue here is that, right? I said in the judge's decision and order, he said that, okay, well, there was no, let me get the quote. That way I'm not misquoting here. Existence of a special duty. It should be dismissed in the entirety due to the absence as a matter of law of the existence of a special duty. Well, listen, there's no special relationship, right? We alleged in our complaint 3 different ways that this was achieved. And there was one exception where, because of the heinous conduct of the cops and the assistant district attorneys, that there was no special relationship needed. The judge ignored the exception and 2 of the 3 ways. All of which we clearly proved and sufficiently alleged in our summons and complaint, facts which the court must accept as true, okay? But the court didn't in our case. The judge focused on the 4 Cuffey factors, claiming that we did not prove the first 2. And the first one is that police assumed an affirmative duty to serve the TOP. And number 2 is that they knew that imminent harm could come to the beneficiary of the TOP if they did not carry out their duty. In claiming we did not prove the first 2, the court ignores the Mastriani Court of Appeals case. So this is another case law that we, brought up and we discovered and we researched and said, wait a minute, this judge is wrong as a matter of this case law. So Mastriani and Court of Appeals case that says the issuance of an order of protection automatically satisfies the first 2 Cuffey factors. So because this family court judge, Hal B. Greenwald, based on our order to show cause and what we alleged about the individual, the witch, erred on the side of caution and took what we said as true, because he issued us this TRO or this TOP, automatically that satisfies these Cuffey factors that this judge is talking about, the first 2. And that was that police assumed an affirmative duty to serve the TOP. Let me put it to everybody this way, right? Why would the police say to me, no problem, we could help you out with the custody exchange, we could serve the paperwork on her? Why would they agree to take my court order and go and serve it upon her if they weren't going to enforce it? That makes no sense at all. Why would you do that? There's no reason. You should have just told me, no, look, we can't help you out with this, and it could have been done. You chose to get involved. So right then and there, you have a duty to me. You're obligated to do something to me because you accepted the paperwork, as you should have. It's part of your job description to go and serve court orders on people. Police officers have the authority to do that. They're mandated to do that. It's their job. You could go and serve a court. You could go and serve, orders of protection and court orders on people. You're well within your duty to do that.
Mhm.
Why would you agree to do that if you weren't going to enforce the order of the court? It makes no sense. So that was there are four things that can constitute the Cuffey factors. It was a case law case back then. I don't know the exact I know it was in I'm pretty sure it was in New York. But out of that case law ruling came these criterion called the Cuffey factors, and there's four of them. And this judge erroneously or mistakenly said that we did not satisfy the first two. We came back with that, as I just wrapped up saying that, wait a minute, we did, because in Mastriani in Court of Appeals case, okay, they ruled that the TOP with the stay away directive automatically satisfies those two factors. So once again, judge is mistaken as a matter of law, and that shouldn't have constituted a dismissal to our civil suit.
No.
Listen, I got no law background experience here. I'm just a guy that got
Oh.
experience, been through the worst. You know what I mean? So
Mhm.
this is all stuff that I'm picking up on, and I'm picking up on it fast, because morally, what happened was wrong. No
Mhm.
one, let me just put it to you this way. No one wanted to help a little 2.5-year-old girl, all right, that was helpless.
Oh.
Morally, to me, I don't care what my job is. That's just wrong. I could not do that. I'll see a cat locked out of a house or a window, and I'll go and help it. You know what I mean? Just that's the kind of person that I am. You know what I mean? A dog wandering around the street, I'll go over there. If I don't, my wife would, beat my butt.
Uh-huh.
But, aside from the fact, I'm just that kind of person. So why no one wanted to help a 2.5-year-old girl is beyond my rationale and understanding. But as a matter of law, like I said, the whole special duty and special relationship is null and void. That was clearly a mistake.
Gee.
Um, I'm sorry. Go ahead.
Oh, I just said, it's it seems like they dismiss a lot of cases left and right. And like you said, really, who's even reading these? It just could be a clerk.
I believe so. I believe so. And listen, I get it. 156 pages, a lot of pages. But as I told you, and as everyone probably picked up on in our first podcast, there's a lot of substance here. There's a lot of stuff going on. A little 2-year-old girl lost her life, but I was, we were at this for over 24 hours. I mean, I was there the day before it happened trying to get her out. And then everything transpired the day after. So, there's a lot of substance here. Like I said, this is no small time case. This is big. A lot of people chose to get involved. The county, CPS, the village police, the assistant district attorneys, the DA's office. I mean, there were a lot of people that chose to get involved in this, and nobody did the right thing. So, of course, there's a lot of substance there. You know what I
Mm-hmm.
mean?
Mm-hmm.
There's just a lot of substance. So please have the courtesy, have the respect to at least read what we're working so hard to attain. All we want is justice. That's
And
all we want.
that's what the taxpayers are paying him for.
That's correct. Yes. I mean, I get it. It's 156 pages, but the nature of what happened, you should put everything aside and say, you
Plus,
know what?
it's all double spaced, so it'd be pretty easy to read.
Right. I mean, look, we spell it out. As somebody could read our summons and complaint, and they could be in the first 2 pages, they'll be like, "Wow, yeah, this guy is absolutely correct here. I
Right.
mean, this shouldn't have happened." You know what I mean?
Right.
You don't have to be a judge or a lawyer or a rocket scientist to understand. Our case speaks for itself. We proved everything.
Mm-hmm.
Um, I could keep on going on about the direct contact requirement and so on and so forth, about Valdez and the Family Court Act, and a whole bunch of stuff on why exactly this judge got this dismissal so wrong. What I just want to touch on, are we doing all right on time, or
I
am I?
haven't been keeping track.
Okay, okay. You know what? I'm pretty close to wrapping it up. Um, I could probably go for maybe another 15.
Sure.
Um, I can go for a lot longer, but I'll just, I'll kind of keep it you know, keep it pretty short. I could keep on going on why the judge, messed up on everything that he said
Oh.
as far as his dismissal goes. But the one thing I do want to touch on is this the technicality part. I want to talk about this CPLR 3211A1. This is all technical stuff. It has to do, as I said earlier, about the way our summons and complaint was filed, about the timing, and so on and so forth. As I said, the team of guys I got, they're great guys. They have families. They're great individuals. And they work hard at what they do. And as I said, over 100 years experience between three of them combined. They know what they're talking about. These aren't no fly-by-night guys. They made a profession and a living out of this. They're honest people, and they work their butts off
Oh.
to really show not only the judge, but everybody else that, hey, look, listen, this is the story, and this is what happened, and it shouldn't have gone down this way. So in our original summons and complaint in state court, okay, that was the one that included our federal claim. That was the subject of the defendant's removal request of the case from state to federal court. Okay. One of our causes of action that we listed in our original summons and complaint, the defendants and all the people that we were suing got back to us and said, well, hey, look, we need to take this out of state court and we want to move it to federal court because this cause of action that you're claiming, which was pretty much that my civil rights were violated, right? The rights to life, liberty, and the pursuit of happiness, parental rights, right to raise a child and a family, all that was taken away from me. And it's an absolutely correct claim. But they were, playing hardball a little bit and said, well, look, if you're going to keep this claim in here, we don't want to try it in state court. We want to move it to federal court. So we consulted and conferred, and we said, you know what? We have a whole bunch of causes of action. I mean, we got them dead to rights on everything here. We could remove that one. So we agreed to remove that federal claim, to have it remand back into state court. We did so after realizing that the federal claim, it wasn't practical, and no one and we all didn't want to be in federal court. I said, we should be good in state court. In hindsight, maybe we should have gone to federal court. It's been a long time since, and maybe we would have had better luck there. But I have faith. I have faith, and I'd like for these judges in the appellate division. I love for these judges in the state court and family court to please, show everybody that you still know how to do your jobs. You're still good people out there. You still want to try cases by the evidence that's put out in front of you and submitted in front of you, instead of maybe how you're feeling or who you're trying to protect or whatever your other alternative motives are. Please show everybody here in the state of New York and in the entire country that you people, you men and women, are competent and you can make the right decisions based on a matter of law and the evidence that's in front of you. So I'm having faith that we'll get kicked back into state court, we'll win the appeal, and we'll be back in state court. I'm having faith about that.
I think you will too.
I think we got a good shot. If you think our summons and complaint is good, I mean, you guys should see our motion to re-argue. I mean, our motion to appeal. It's a masterpiece, second to none. Once we're back in state court, or once we were back in state court, our team amended the original complaint to remove the federal claim, and we added several more causes of action similar to the original in regard, but more comprehensive to the New York State statute that permits us to amend the complaint once as of right, without the need for a court order allowing the amendment. So this is all the technical stuff that I'm talking about that this judge erroneously dismissed the suit on. This is what we did, and what we did was the correct way to do it. Once that amended complaint that we filed, okay, was dismissed, we sought to submit a second amended complaint, okay? But we needed the court's permission to do so. The court did not permit us the filing of the Second Amendment complaint because it said the court would have dismissed it if it was filed for the same reasons it dismissed the First Amended complaint. So why should we allow the Second Amendment complaint to be filed? If you're going to dismiss the Second Amendment one, and we have to ask you as a matter of a statute to submit a Second Amended one, and you tell us, well, we're going to dismiss it because it's the same as the first one. Why are we even submitting a Second Amended complaint? To be filed. Of course, we contend on our pending appeal that we have that the dismissal was wrong because the court wrongly held that the witch had the Fourth Amendment rights to privacy in her home, and that the police could not enter her home to arrest her for the stay away violation of the TOP without an arrest warrant. Okay, which we just claimed that whole thing that we read about the warrant was obviously false and it was misconstrued by the judge. The court relied on the wrong case. The judge based his rationale that we needed a warrant based on case law, Payton versus New York and U.S. Supreme Court. That case law case was not relevant to our situation in court. The more relevant case law was this case called United States versus Santana, which was a U.S. Supreme Court case. And the ruling on that case says that the doorway of a private dwelling is constituted as a public place, and individuals are not afforded the right of privacy inside a doorway. They can't close their door and hide behind it when you are in the doorway of your home. This court case ruled that it is a public place. Okay. And that's a major, major win for us. It's a major victory because guess what happened? That court order that I showed you guys in my story that I told you was served to her while the witch was in the doorway. It was read to her. It was understood by her, and she accepted it in the doorway of the home. Okay, and she slammed the door, and right there, as I said, crimes were committed that mandated an arrest. Criminal contempt, obstruction. There was multiple crimes there. Custodial interference. They could have went in there for any one of them. And I mentioned those also in the first podcast that we did. I'm sorry. So that's what that case, U.S. versus Santana, said. So right then and there, it kind of shoots the judge's decision to dismiss our order down, saying that she was afforded protection under the Fourth Amendment. Okay, that's not true. The court also wrongfully disregarded that, we're going back to the special duty now, that I satisfied the special duty requirement to sue a municipality for declaration of duty of its police officers, despite my unrefuted and undisputed affidavit that permissibly supplemented an amended complaint that the police promised to get custody of my daughter, as the TOP said. And that once I gave the TOP to the police officers, they were not only able to serve it, but they had to enforce it. Okay? Right. I had no choice but to rely on them to enforce that court order. Okay? That's part of their job description, and they have to deliver on what they promised.
So they're not educated enough to go do this. They must not have been educated enough to realize they have to follow through with this.
That's what it sounds like. That's the only conclusion that could be drawn is, like I said, that why would you accept to serve a court order, an order of the court that a judge that's way higher than you on the scale afforded me the protection of, and my daughter, more importantly? Why would you agree to serve that court order but not enforce it? It doesn't make any sense to me.
No.
So I justifiably relied on those police officers to do their job, and they failed miserably.
Mm-hmm.
Um, because a little 2-year-old girl lost her life. Um, Now, another thing is that that was the special duty that we were talking about. He said there was no special duty that existed. Of course, there was a special duty that existed. I relied on the police justifiably to serve and enforce a court order. I could not do that myself. Um, and I even said to the cop, I said, look, if you want, I'll go into the house and serve it. I'll go into the house and get my daughter, and you guys could witness it. And they told me, no, we'd have to arrest you for trespassing.
Oh
So,
God.
if you don't want to do it, or you're saying you can't do it, or you're unsure if you could do it, and the
Uh,
assistant district attorney doesn't know what they're talking about because they're advising you now that it's a civil matter and it's not criminal. Meanwhile, I just listed about 4 crimes that were committed in the presence, in a public place, the doorway, mind you. Then who has the authority to go in here? Which is what my attorney Martin Rosen said to the DA, the assistant district attorney, on the phone at the time, and said, "Well, if you don't know if you have the authority to go in there, then who should we call? Should we call the Marines? I
right.
mean, should we call the Marines to go in there then? I mean, this is
Uh,
ridiculous." We believe that the ADAs did not go into the house because the district attorneys did not advise the police to go into the house, right? Because, of course,
mhm.
the cops didn't know what they were doing, so they got to call the higher ups, and it makes its way to the on-call assistant district attorneys
Yep.
that night. There was 2 of them. Um, and they had no idea what they were talking about either. Um, they said not to go into the house. Now, the only reasons we can think of why they told the police not to go into the house is because they didn't know the law themselves, which that's their job, to know the law and advise the police on criminal matters.
Mhm.
The woman that we spoke to that night, you know, Assistant District Attorney Mary Clark, said that it was a civil matter, and that's completely ludicrous and
Oh,
false, because it's not a civil matter. It might have started out as a civil matter, but it wasn't a civil matter after she slammed the door shut in the police faces and didn't comply with a court order. I mean, that's criminal. So she didn't know what she was talking about. So they didn't know the law, and the particular set of laws, as I said, was the CPL laws and obviously the case law of Santana. Or they did not treat the witches violation of the TOP, of the TRO that I have, as a crime that it was, which
mhm.
was clearly a violation of a court order in New York State, is a crime. Okay, it's criminal contempt. But instead, they considered it to be a mere domestic dispute that they'd rather not get too involved in. Or 3, that their ignorance of the law and unwillingness to get further involved by entering the house to enforce the TOP was because that they were afraid of getting sued. These are the only 3 reasons we came up with collectively as a team to think on why these people made the choices that they made on that night, on that evening. Um, because I think I just spelled it out for everybody in black and white that we got them dead to rights here. I
Mhm.
mean, there is no way around this. The law is the law is the law.
Mhm.
So, I mean, and if they were afraid of getting sued, I'd rather get sued by, um, you know, by at least being able to maybe go into the house if I wasn't sure, to save a life,
Right.
and get sued for wrongful entry or whatever kind of, BS you want to try and throw at me, than not try at all and let a little girl suffer the fate that she did, and then have to get sued by a father that lost everything,
Oh,
and
God.
have to live the rest of my life in law enforcement or in the field of law enforcement to say, hey, I messed up, and this was 100% preventable, and I'm still getting sued. At least he would have got sued for the right reasons. You know what I mean?
Right.
And that didn't happen. Um, so
Mm.
I'd just like to end with this. Um, as opposed to, just to kind of culminate and wrap this all together. I think we did a really good job of explaining to everyone on how Justice Hubert over here made an egregious mistake on his decision to dismiss our civil suit
Mm.
in the entirety as a matter of law. Not, once again, we can go into semantics and we could talk about morals, right? Morally speaking, like I said, just be straight, James.
Yeah.
Think about what happened here in the whole grand scheme of things.
And
But
read the document that was submitted.
right, read the documents. I mean, as I
God.
said, not only as a matter of law, but just morally speaking. Stop
Mhm.
trying to protect people. Stop trying to, delay the process and stall out the process. Wait for people to retire. Wait for people to get older and forget things. I'm
Oh.
not going to forget. I
Mm-mm.
got I got paperwork all over the place. Look, I got a whole bunch of stuff. You
Yeah.
know what I mean? So I'd really just like to wrap this all up and you know, the real lesson to be learned here, okay, is that violations of orders of protection, temporary restraining orders, temporary orders of protection, okay, must be treated like the crimes that they are and acted upon by police like any other crime. And until the courts enforce this concept, more innocent beneficiaries of these court orders are in danger. You can
Hmm.
mark my words. Domestic violence is real. It happens. Child abuse is real. It happens. And when a judge issues an order of protection or a temporary restraining order, police need to recognize it. It needs to be treated like the crime that it is, and lives will be saved.
Hmm.
And that's how I'd like to end this.
Oh, yeah, I'm very sorry. I really hope they hear your case or rule on it soon. It's been so long.
Yeah, it's been a
Oh,
while. And like I said, people come up to me every day and hey, what's going on? Do you hear anything? And for years I've been telling them, it was still waiting, still
yeah,
pending. We're still on the list. And we will continue to do so.
right.
It's just as I said, to me, when you connect the dots and you read the writing that's on the wall, everything points to a cover up, everything points to shady, backdoor kind of deals and who's protecting who and what motives, alternative motives, what narrative we're trying to spin here. And it just doesn't look good. And my plea is to these justices, to the judges and the attorneys and everyone involved, and not only my case, but everyone else's case.
Hmm.
Just look at the evidence that's brought before you. That's it. If you do that, I'm sure you'll get it right.
Oh, God bless you. I'd like to have you come back on again,
Yeah.
in the future, and hopefully this will be
Hopefully we'll have some good news.
yeah, 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 please, But how can people reach you if they have any questions?
Yeah, absolutely. We have our website, which is, obviously up and active 24 hours a day. We have our contact information there. It's been recently updated and revamped. We're really proud of it. It's Gabriella Boyd Foundation.org. Uh, that's Gabriella Boyd Foundation.org. We also have our office number. As I said, it's all on our website. We're on social media, Instagram, Twitter. You could definitely find us on there, Facebook. Um,
Hmm.
and as I said, we'll be out in Poughkeepsie next week alongside National Parents Organization and a few other big organizations protesting for family court reform.
Hmm.
Um, and we've kind of transitioned into that kind of a work where our organization is really starting to try and lobby for change and really get some kind of legislation and reform going.
Yeah.
But once again, if anyone has any questions or concerns about some kind of a family court, case or lingo or hearing, that was grassroots. That's how we started out.
Hmm.
Based off of what happened to me from episode one that we did together, Marianne, and
Hmm.
my whole saga that I went through.
Hmm.
I am ready, willing, and able to help out anyone as best I can with any kind of concerns or questions that they may have going through this family court process. So feel free to reach out to us and leave a message. If we don't pick up, guys, please just leave a message. We will get back to you.
Well, thank you so much. Don't jump off, okay? Slam
Absolutely.
Slam the Gavel is a podcast to help the public understand what really goes on in these family courtrooms. I'm your host, Marianne Petrie, author of Dismantling Family Court Corruption, Why Taking the Kids Was Not Enough, and Cry Out for Justice, Poems of Truth, and Raised by These Wolves, How Family and Federal Courts Are Failing Our Children. You can find me on Spotify, YouTube, Apple, iTunes, Anchor FM, other platforms I don't know about, and feel free to buy me a coffee to help keep this podcast going. Thank you so very much, Stephen Boyd. Thank you.
100%, Marianne.